Good morning. Welcome to the House Judiciary Non-Civil Committee. Let me recognize Judge Ginsburg of Savannah on behalf of the state court judges. Welcome. Thank you for being here. If anything occurs that we're not catching, and you do, I'd ask you to please come forward and let us know by any means necessary. But seriously, we appreciate your being here. It's a real asset, and we appreciate it. Judge Boggs was here yesterday in the office. He's not here this morning, but I'm sure we'll see him from Waycross. We'll see him today or tomorrow, no doubt. We've got 3 bills on the calendar. Whatever we don't finish today, we will not obviously finish all 3 today. We will carry over for tomorrow morning at 9 a.m., tomorrow morning 9 a.m. Here in 132. We'll start off with see if we can go ahead and finish up 897, get to a markup and a motion on the Chase legislation. House Bill 897, Representative Collins.
Thank you, Mr. Chairman. As we have went through a couple of long and well discussed meetings, I wanted to bring back to you and then basically just turn it back over to the committee. A couple of changes that came out of our last meeting. One, school is now defined on line 24, page 1. We took that language. I want to thank Jill tremendously for her help in this. She actually went to great lengths to get the education. This is actually language from education. Betsy Malta from the Ledge Council had worked on that. So that just defines school. The other issue was taken out as far as change was the enrolled and attending. We took that language out.
And where is that?
That was on page 3, line 71. It's now just enrolled. That was a good point brought up the other day. You can't be enrolled. So if you're enrolled, you're going to be attending. So
okay.
Taken care of. At this point in time, I think those were the main discussions from last time. Again, I want to keep in the environment of a teacher setting that the student and teacher relationship with students' consent is not going to be a defense in this. And I think we've covered a lot of the scenarios, and I appreciate the work of the committee on both sides of the aisle on this to make a bill that I believe can be workable. Mr. Chairman, I turn it back over to you.
Thank you. Questions for the author, Mr. Vice Chairman?
Representative Collins, just one quick question, and for the benefit of those here in attendance that are may not have heard the other hearings we have. This will take away consent as a defense to a prosecution, regardless of the age of the student. Is that correct?
Yes, and it will say it's have to be over 16 anyway to have consent as an issue. So it's that issue. It's not going to be a part of that process anymore. And that's what we're doing.
So whether it's 17, 18 does not matter. Is
right,
that?
And that's what's covered. And we did the Romeo and Juliet provisions. We tried to cover every situation we could to make sure any unintended consequences as best we can. And as you know, that's a difficult situation right here. As best we can, we've addressed those.
Thank you.
In this bill.
I guess it. Thank you.
Mr. Chairman, one thing. After discussions the other day, we did in line 78 took out volunteer and hospital after the discussions with agent and everything else and the discussions around volunteers. So.
Would you go ahead and point that out to us again?
That line 78, page 3.
So volunteer was removed.
Yes. Because after the standard definition of agent, we felt like we fall under.
Okay.
Okay.
Ms. Benfield. Ms. Benfield, are you on?
No.
Oh, okay. Mr. Mangum.
I'm trying to find it, but I didn't get a chance to get clarity on our last discussion. As you know, I am a proponent of this, the Romeo and Juliet exception, and I really agree with the concept of your legislation. I want to say that all in all, particularly saying that consent shall not be a defense. I'm all with you, and I'm on board with that. My concern, quite frankly, is prior to taking this consent away, I think it's section, okay, my colleague just pointed out, line 898. Prior to this legislation, is there a mandatory minimum if you are within the Romeo and Juliet exception? For example, if you're outside of the Romeo and Juliet exception, we did pass that last year before last, or whenever we passed the Romeo and Juliet exception to deal with some of the unfortunate consequences, and the Supreme Court was all involved. In Leg counsel may be able to assist. I just didn't get a chance to get this at our last meeting. Because right now, the example that I gave you before about a 15-year-old and a 19-year-old, there was 4-year, I believe you were making it a misdemeanor. Are you still making it a misdemeanor if they're within the, because I don't see that.
Yeah, with inside Romeo and Juliet, it is still a misdemeanor, which will be found on line 101.
Okay.
Excuse me, 100.
Okay.
Yes, it falls within the Romeo and Juliet division.
But if it falls outside of the Romeo and Juliet exception,
It would fall to the actual language that has been in this bill since the beginning, and what we did, the 1 to 25, 4 by 5, which found the lines 92 and 93, which is probatable and can take into account situations.
now you just said 1 to 25, but is it not true on line 96 that there's a mandatory minimum of 25 years to serve?
Yes, it is, but under line 95, it also says that they're under 16 years of age. And this is when the consent's not an issue in Georgia anyway, because consent kicks in at 16. If they're under 16, it's a different, this is not even addressing this issue.
So, if you're under the age, let me be very clear, and let counsel can help me. If you're age 15,
Okay.
right now, and you have sexual relations with a 19-year-old, are you going to be subject to the mandatory minimum of 25 years to serve in jail, as the current law is? N-
Supervisory disciplinary, the 19-year-old. This isn't just sexual relations outside of this context. You've got to have a teacher or a hospital setting, but if you have that situation and it's consensual, it could be treated as the Romeo and Juliet.
Okay.
I think they can't actually rape.
It's statutory rape. This is a different issue. This bill really doesn't address that. I understand your concern, but this bill is a different issue.
So,
in this regard.
so this will only apply in the supervisory
Right, exactly.
role. That's
Exactly.
fine. Thank you.
Okay.
Ms. Abrams.
Actually, I appropriate motion.
All right. Ms. Banfield, did you have something?
Now I do, but
All
this
right.
is just clarifying. I think my understanding of statutory rape is under the age of 16, the law does not recognize that you even have the capacity to consent.
Exactly.
And so that's just in keeping with already existing law about under the age of 16. And the assistant DA on our committee is nodding. So, and I just want to make sure I understand that obviously this covers not just conduct in the school, but the other facilities would be long-term care facilities, hospitals, probation, parole offices, and jails and prisons. Is that correct?
And police.
And police. Okay. I just want to make sure I understood who else was
It
covered.
does. This is all in a big code that we just laid it out.
Yeah, because some of these code sections, it doesn't say what facilities they are, so I want to make sure
Okay.
about that. Thank you.
Mr. Levitas.
I'd like to be recognized for a motion at the appropriate time.
I don't see any other lights flashing. I'll go ahead and recognize you for that motion. I know, Ms. Abrams, you have a proposed amendment. Is that correct? Yeah,
we
let's
have
go
to.
ahead and do that. We'll take the motion in the second, then we'll go to the amendment. Mr. Levitas.
I move we do pass LC 294090S.
By motion and second of due pass by committee substitute LC 294090S. Ms. Abrams.
First, I want to thank Mr. Collins. He's been incredibly helpful and thoughtful about working with all of the members of the committee and all of their recommended changes. My last one is actually on line 102 and 103. The effect of this language is to remove the option of merger, which I think, number one, removes judicial discretion. Number two, it just allows people to load up on, I don't see a compelling reason to include merger language in this statute, given that the facts of this would have to be so specific. And so would move that we strike lines 102 and 103.
Ms. Abrams offers the amendment of striking lines 102 and 103 and relettering accordingly. Mr. Levitas.
I just quick objection to that. This is a separate offense, and while certain offenses like statutory rape could merge if this were left, these are separate and distinct offenses, and the nature of the relationship suggests to me that we ought to leave that in there. It ought not to merge, and if somebody's committed statutory rape, they ought to be subject to that punishment as well.
If I may respond.
Certainly.
While I understand my colleague's concern, my concern is that this is a fairly expansive bill, and it covers more than just the simple issue of statutory rape. And what you're creating is the opportunity for fairly egregious or fairly long sentences. And we do not, I believe that eliminating the merger option is inappropriate at this time. I think that were this a very narrowly tailored law that only affected a very specific set of issues, I would be comfortable with that. But this is a fairly expansive law, and I think necessarily so. But you're removing consent, and you're including a number of different provisions in this. And so I think that the removal of the merger language is problematic.
Right. The difference here is that you're talking not about consent in the ordinary context. You're talking about people with a very specific relationship where they lord over these folks. And so, again, we could go back and forth. It's a policy disagreement. Again, I think this is a separate offense, and it merits separate punishment that should not merge with the statutory rape.
It is a pure policy question, and I appreciate the dialogue. Ms. Medfield.
Thank you. Does the amendment need a second, or is it okay? I want a second, and then I also just want to briefly state that
I don't know that an amendment actually needs a second, but
I second if it does.
the lady has that right.
But I support it because I see it as a matter of judicial discretion, and to allow our courts on a case-by-case basis to decide whether it would be appropriate to have the offenses merge or to have them run back-to-back. And I can certainly think of many compelling cases where the sentences should be back-to-back. But I would leave that up to our judges. I trust our judges. We elect them. They're accountable to the public. And I think that they can make the best decision on a case-by-case basis instead of hamstringing them.
Mr. Ramsey, then the vice chair, then we'll move to a vote.
I just want to ask the author if he has an opinion as to the amendment, or Mr. Collins, do you have an opinion as to the amendment?
It's not in my preference, but I'm glad to get the committee. Okay.
Mr. Vice Chairman.
Thank you, Mr. Chairman. I would ask Representative Abrams perhaps to clarify. My understanding is that the issue of merger is not one of consecutive versus concurrent sentences, and it's also not an issue of judicial discretion. Merger is a concept of using a single set of factual circumstances and allowing that set of factual circumstances to cover the commission of more than one offense. And so we would I think the norm in our law, and Ms. Travis can correct me if I'm wrong, but I think the norm would be that you would not have a situation where that same set of facts would constitute commission of several offenses. In other words, that there would not be multiple offenses arising out of one factual set. Is that true?
Well, I think the distinction with this particular crime is that it sets it apart from a sexual battery or from statutory rape or from a child molestation, in that you have to have some relationship between the actor and the victim, either supervisory, disciplinary, or it's a psychotherapy relationship, or it's a hospital setting. So while it could be prosecuted on those other facts, if all the facts are eaten up, then you don't have to deal with it. But I don't think you're ever going to have all the facts eaten up if you can prove supervisory and disciplinary and advanced.
Well, if we take this language out, then and you have a situation which would otherwise constitute a statutory rape, then a prosecution for statutory rape would then preclude a prosecution under this section. Is that true?
I'm not 100% on that, but I know you have Mr. Moss, who is the district attorney, who is prosecuting versus they'd probably be prosecuting.
Could we hear from him?
I think that's, I'd like to hear. Mr. Moss, did you hear the question?
I'll ask the question again. If we took this language out in lines 102 and 103 regarding merger, and then you had a situation arise which would otherwise constitute the offense of statutory rape, then a prosecution and conviction for the offense of statutory rape would preclude a conviction under this code section. Is that true?
Either way.
Well, I agree, but I'm just asking it. Okay.
And merger is a matter of law by a judge, not a discretionary. Isn't that correct? It's a constitutional issue.
Let me give the author the last word. We'll proceed to a vote. Author of the amendment.
Thank you. Again, my point is the exact conversation we've just had, which is that there's nothing, I believe, that would preclude merger or would disallow merger. But this language specifically disallows the judicial discretion that could permit merger. It says it shall not merge with any other offense. My issue is that this language I don't see as necessary to affect the change that Mr. Collins is seeking, and would ask that this body remove that language because it doesn't affirmatively support the goal of this bill, but it does create some ambiguity that I find very problematic, given that within the last 5 minutes we've discovered that there isn't a clear understanding of what this can and cannot do.
Mr. Levitas, hold on one second.
The problem is that merger is not within the discretion of the judge. It's a constitutional issue. The discretion of the judge would be, if he's convicted under this and statutory rape, the judge, he or she, may run them consecutively, concurrently. That's where discretion is. But merger is not a discretionary. It's a matter of law, and if it merges, it merges. Period. They don't have discretion.
What's the need for this language in this bill? Here's my concern. When reading this language, I went to see both a judge and a defense person to ask what it meant, and I got two separate answers. In this room, I got a third answer. My concern is that practitioners do not clearly understand the point behind this language, and the goal of this bill is a very clear one, and I think a very important one, and I would ask that we remove this merger language given the ambiguity, and I appreciate your very staunch defense of it, but I think that there is clear ambiguity, and it doesn't support the underlying premise of this bill, and I would ask for my amendment to be approved.
And the only thing I would say is that we have non-merger language throughout the code, and it has not been a constitutional problem.
Let's good debate, good dialogue. It's a policy matter. Let's go ahead and bring it to a vote. The question occurs on Representative Abrams' amendment to strike lines 102 and 103, the merger language that we've just been discussing. All in favor of the lady's amendment, please signify by raising your hand. All opposed? And the amendment passes 5 votes to 3, as I recorded it. 5 to 3? Yeah. Is that correct? 5 to 3? Okay. The question then occurs on the motion of due pass by substitute as amended. All in favor, please signify by raising your hand. And opposed. And the motion carries, and the report will be due pass by substitute as amended. Thank you. We will. I have it. Let's have a little order. I have it at 9:52 a.m. Folks have to have the ability to get upstairs if they want to, and that's fine. That's their discretion. If they do not, and we still maintain a quorum, we'll have those 2 bills. We still will have to go ahead and meet tomorrow morning. Let's go ahead and do that, so we don't rush too much. Mr. Lafayette, by committee substitute as amended. Oh, you can do it by new committee. Okay. All right. That's fine.
Can we thank Judge Mike Boggs for being here?
Well, I did, but he wasn't here on time. But I'll do it again. Judge, thank you for being here. Ladies and gentlemen, we'll go ahead and meet tomorrow morning, 9 a.m., for the other 2 bills on the agenda today. Tomorrow morning, 9 a.m., please. We're adjourned.